Assalamualaikum and a very good day. We are Group 7 and today we will be presenting on the topic of cautions under the Contracts Act 1950. Let's begin with our first slide on the introductions to questions. Hello. Okay, the introductions, the legal concept of questions. So today our group will be presenting on the legal concept of questions. So what is questions? In simple terms, questions happens when one party forces another person to enter into a contract through threats, violence, or unlawful pressure. There are few key points to understand here. First, questions involve force, threats, or unlawful pressure. This means the person did not agree willingly. Second, it prevents free and voluntary consents. Without genuine consents, the agreement is not truly valid. And the third, the coerced party has the right to cancel or avoid the contract. The law protects the victim by making the contract viable. Now let's move deeper into the definitions and legal provision in the next slide. Now let's take a look at the formal definitions of cautions under Malaysian law. So, in simpler terms, cautions mean forcing, pressuring, or threatening someone to do something against their will. It includes the use of force, threats, intimidations, or undue pressure to influence a person's decisions. There are two key aspects to remember here. First, property detainment. This means unlawful detaining or threatening to detain any property belonging to another person, for example, refusing to return someone's land title unless they sign a contract. Second, intentions. The act must be done with the specific intent to force a person to enter into an agreement. Without this intention, it may not qualify as a caution under the law. So to summarize, caution is not just about physical violence. It can also involve threats to property, and the key element is that the person's free will is taken away. Let's move on the next slide, where we take a look at the elements of cautions in more details.
First, coercion means forcing someone to enter into a contract by using threats, illegal acts, or unlawful pressure. When consent is obtained through coercions, it is not considered free consent. These are three main elements of coercions. The first element is committing or threatening to commit an act forbidden by the penal code. This means one party threatens to do something that is against the law to force another person to sign a contract. For example, if someone threatens to physically harm another person unless they sign an agreement, this is coercions. The second element is unlawfully detain or threatening to detain property. This happens when someone wrongfully keeps another person's property or threatens not to return it until they agree to a contract. For example, if refusing to return someone's car unless they sign an agreement, it is considered coercion. The third element is the intention to make a person enter into an agreement. The threat or unlawful act must be made with the purpose of forcing the other people to give their consent. If there is no intention to obtain consent, then it may not be considered cautions. Finally, what is the effect of cautions? If a contract is made because of cautions, the consent is not free. Therefore, the contract is voidable, which means the affected party has the right to either continue with the contract or cancel it.
What are the legal effects of coercion? According to Section 9 of the Contract Act 1950, when a person consent is obtained through coercion, the contract becomes voidable at any option of that person. This means that the affected party has the right to decide whether to continue with the contract or to cancel it. Okay, the first legal effect is the coerced party may cancel, or we call it as rescind, the contract. A party who was forced into an agreement may choose to cancel the contract, and they are not longer bounded by the term of the agreement because their consent was not given freely. Okay, the first legal effect is the coerced party may cancel, or we call it as rescind, the contract. A party who was forced into an agreement may choose to cancel the contract, and they are not longer bounded by the term of the agreement because their consent was not given freely. Okay, the first legal effect is the coerced party may cancel, or we call it as rescind, the contract. A party who was forced into an agreement may choose to cancel the contract. Secondly, restitution may be required. If a contract is rescinded, any benefit received under the contract may need to be returned. This is to ensure that both parties are restored their original position as far as the possible. And finally, the coerced party may accept and continue, we call it as affirm with the contract. The affected party may also choose to accept and continue with the contract. In this situation, the contract remains valid and enforceable even though coercion was involved at the time of agreement was made.
In this case, the respondent agreed to purchase houses from the developer for 29,500. However, after the agreement was signed, the developer demanded an additional 4,000 from each buyer and threatened to cancel their house booking if they refused to pay. Because the buyer were afraid of losing the houses, they paid the extra amount. They later brought the case to court, claiming that the payment was made under caution and asking for a refund. The appellant argued that the buyer had agreed to pay the additional 4,000 voluntarily for the extra work on the houses. They also claimed that threatening to cancel the house booking did not amount to coercion under the Contract Act 1950. However, the High Court disagreed with the appellant argument. The court found that the buyers only paid the additional 4,000 because they were afraid that their house booking would be cancelled. Therefore, the buyer did not make the payment out of their own free will. As a result, the court ruled that the payment was made under caution under Section 73 of the Contract Act 1950. The buyer were entitled to recover the 4,000 they had paid. The court dismissed the appellant appeal and upheld the magistrate decision. This case showed that when a person makes a payment because of threat or pressure, their consent is not truly voluntary, and the law may allow them to recover the money.
Now I will explain the difference between cautions and undue influence. First, let's look at the cautions. Caution happens when a person is forced to enter into a conflict through threat, violence, or other unlawful acts. In this situation, the person's consent is not given freely because they are afraid of the consequence if they refuse. Since the agreement is not under pressure, the consent is considered invalid. Next is undue influence. Undue influence is the different because there is no threat or physical force involved. Instead, one person takes advantage of their position of trust, authority, or power to influence another person's decision. The weaker party may agree to the contract because of the relationship between them, even though they will not have made the same decision on their own. In summary, the main difference is that cautions use force, threats, or unlawful acts to obtain consent, while undue influence relies on a relationship of trust or authority to influence someone's decision without using force. That's the difference between cautions and undue.
Okay, let's talk about legal professions. Who are the legal professions? Lawyers, prosecutors, and other legal practitioners uphold the pillar of justice. They advocate the truth, protect the rights, and guide all the individuals and institutions in navigating complex legal system.
Caution under Section 15 of the Contracts Act 1950 refers to a situations where a person is forced into entering a contract through threats, violence, or other unlawful pressure. Since the person's consent is not given freely, the contract is voidable at the option of the party who was coerced. It is also important to remember the difference between cautions and undue